Hello, and welcome back to the Supremely Simple Court, the Supreme Court podcast where we make the court easier to understand. Hello, everybody. My name is Catherine Caesar, and I am gay, and I'm one of your co-hosts.
And I'm Eli Raymer, your other co-host, and I am an ally.
So the case we'll be covering today is called United States v. Skermeti, but unfortunately, we're not actually covering it today because there is a lot of really important precedent that we need to cover before we talk about this case, which deals with anti-trans legislation in Connecticut. What is Connecticut? Not in Connecticut. In Tennessee and in Kentucky.
For this episode and the next episode, we're going to be covering a brief history of LGBTQ plus rights at the Supreme Court, and specifically today starting with the creation of and the finding of the right to privacy, which is pretty big.
Exactly. So the cases that we will be covering over the next couple of days include Griswold v. Connecticut and Eisenstadt v. Baird, which we will both cover today in today's episode. And the next episode, we are going to cover Lawrence v. Texas, Obergefell v. Hodges, and Bostock versus Clayton County. And those cases go more into solidifying specifically LGBTQ rights based on the zone of privacy precedent. And Griswold and Eisenstadt kind of established that zone of privacy. Especially we will talk about for married couples and for single people when it comes to the rights to contraceptives.
Yeah. So let's dive into the facts in Griswold. So in 1897, Connecticut passed a law barring all forms of contraception as a means of preventing illicit sexual relationships. So that was the aim of the law. And so they thought if people would not have access to contraception, they'd be less likely to engage in the activities due to the risks of pregnancy. So a gynecologist at Yale, C. Lee Buxton, opened a birth control clinic in New Haven, where Yale is, alongside Estelle Griswold, who was the head of Planned Parenthood Connecticut. And they opened this in 1961. They were arrested for violating the 1897 law, and their convictions were upheld on appeal, and I think they were each fined $100. They opened the clinic with the idea of being arrested and being charged in violation of this law so that they could challenge it. Previously, Dr. Buxton had started a clinic of a similar kind and then had sued on behalf of him and his patients in the case Poe versus Ullman, but the court determined that he didn't have that there was a ripeness issue. So ripeness is one of the things that is required in order for the Supreme Court to hear a case in most instances. And in this moment, they had not been charged or arrested. There was only a threat of arrest. And so since there was no harm that had been done, the court had no remedy it could provide. So it was not a ripe case. So that was why they set up the new clinic, managed to get charged by the law so that they actually had a ripe case that was directed at themselves that they could bring to the court.
Exactly. And as we had discussed in actually our first episode, our inaugural episode, dissenting opinions are often used as the groundworks for majority opinions or concurrences with future cases. So justices will often either cite themselves, cite each other, cite decisions or concurrences and dissents that they really agree with. Although we discussed dissenting and concurring opinions do not set precedent. They are just there to provide what a certain justice is thinking about and how they differ from the majority opinion. So in the case of Poe, which we just discussed, Justice John Marshall Harlan II, what a name, by the way, authored a dissent, which is one of the most cited dissents in Supreme Court history, as it served as the basis for the challenge in Griswold. So I'm going to go full quote here. It's quite a long one, so bear with me. End quote, or begin quote, not end, I didn't start saying anything. In it, he said, the full scope of the liberty guaranteed by the Due Process Clause cannot be found in or limited by the precise terms of the specific guarantees elsewhere provided in the Constitution. This liberty is not a series of isolated points pricked out in terms of the taking of property, the freedom of speech, press, and religion, the right to keep and bear arms in the United States, the freedom from unreasonable searches and seizures, and so on. It is a rational continuum which, broadly speaking, includes a freedom from all substantial arbitrary impositions and purposeless restraints. the idea of a zone of privacy, technically not officially established until Griswold,
Mhm.
but this was what kind of set the groundwork for it, as it's not, privacy doesn't appear anywhere in the Constitution.
Nope.
It's a completely implied right, which to me, honestly, kind of sidebar, is kind of shocking considering the time at which the Constitution was written
Mhm.
directly after independence from Britain. I would assume that these founding fathers would want to have a sense of privacy and establish that, but at the same time, different time period. Clearly, invasion of privacy wasn't really on their radar
Mhm.
when it came to, I guess, what we experience now in like forms of policing or surveillance or things of that nature. So yeah, it is a complete. It's not an enumerated right, so it's nowhere
Mhm.
in the Constitution, and it has been cited in many different amendments. We'll talk about, but mainly the basis for the zone of privacy would be the 14th Amendment's Equal Protection Clause, the 14th Amendment's Due Process Clause, and I believe, at least in Roe, when they cited zone of privacy, the Ninth Amendment, which is rights reserved to the people,
Mhm.
and the Fourth Amendment, which was unwarranted search or seizure.
That's
So
right.
all those combined kind of amplify the zone of privacy argument.
We'll get into how the court determined what the zones of privacy were and where it was derived in Griswold, as there is a majority opinion that has one idea, and there were three separate concurring opinions that all have different ideas where it comes from. So the question that the court takes up in Griswold um, is does the Constitution protect the right of marital privacy against state restrictions on a couple's ability to be counseled in the use of contraceptive? So, the reason why this is the question they take up is because the law specifically excludes married couples. So, the 1897 law in Connecticut said married couples are fine to use contraception, unmarried people cannot. That is the oh no,
Yeah.
it says both. Excuse me.
Yeah.
It says no one has a right to contraceptive, and so these clinics were specifically catering to married people.
So on to the holding. The court ruled in 7-2 favor of Griswold, with the majority opinion authored by Justice William O. Douglas.
So the reasoning that Douglas uses in Griswold is that the right to privacy can be derived from several amendments to the Constitution, and it is not found in the substantive due process doctrine. So in the 14th Amendment, there is the due process clause that everyone is entitled to due process of law before they are deprived of life, liberty, or property. That's also derived from the Fifth Amendment. And so there was also a doctrine that's known as procedural due process. There's also the doctrine of substantive due process, which says that the 14th Amendment also protects citizens from substantive laws that govern how they are to behave and protect people from government overreach, even if that right is being infringed on is not specifically mentioned in the Constitution. So it's a doctrine they took up that gave broad deference to people, and oftentimes was used to overrule state usage of police powers. So the court moved away from this doctrine in 1937 with its decision in West Coast Hotel Company versus Parrish, and they determined that we will no longer use substantive due process. We will defer to the state's police powers. Stop bringing cases of this nature because we will not hear them. So he found there were Justice Douglas found there were penumbras or zones created by the amendments of the Bill of Rights. The court concedes that the right to privacy is not explicitly mentioned, but privacy in marital relations can be derived from the First, Third, Fourth, and Ninth Amendments.
Hold up. Sorry. Third Amendment. Drawing and quartering.
Oh, sorry. Thank you for the correction there. The First, Fourth, Fifth,
There we go.
and
Okay.
Ninth Amendment. Thank you very much.
Drawing and quartering. I was like, what is that?
Yeah, that would really be something.
That'd be funny.
In the First Amendment, of course, freedom of speech, religion, press, assembly, and expression. The Fourth Amendment is, quote, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The Fifth covers due process when it comes to government takings and the right against self-incrimination. And then the Ninth is, quote, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So that's saying that even though we don't say every single right that is here, regardless of that fact, people are still afforded these rights and protections.
Exactly. Which directly following that is rights reserved to the states as well. So the Ninth Amendment is typically used for cases like with civil liberties, and the 10th Amendment is typically used for cases of separation of powers, as we have discussed in our professor's common law classes. But in this decision, there were quite a few concurrences and different opinions, because it is, or was, I guess, at the time, such a kind of made up idea. Like it wasn't an exact doctrine, it wasn't an exact precedent, so people wanted to kind of test the waters to see where they could derive this right from. And justices had several opinions on where that right should or should not come from. So several justices, as I said, chose to concur, generally to propose their own version of where privacy is derived from. Justice Goldberg, joined by Justices Warren and Brennan, so those were very typically liberal justices, Earl Warren being the Chief Justice at the time, known for a lot of really important civil liberties cases, especially when it came to LGBTQ rights and things of that nature. And I believe he authored the decision in Brown.
I think you're right.
I think he did. I could be wrong. But he was definitely on the court during Brown. I know that for a fact. And he was the kind of guy that demanded unanimity, which is the reason that Brown was a unanimous decision. But that was kind of a sidebar. But in that decision, they found that the right to privacy only existed in the 9th and 14th Amendments, and that the text of the 9th Amendment, which covers rights reserved to the people, was enough to justify the right to privacy, even though it was not explicitly enumerated. So they're kind of using this broad interpretation of the 9th Amendment and saying that it covers absolutely anything that we really wanted to when it comes to rights reserved to the people. And then Justice Harlan concurred on his own, and he kind of wrote that the 14th Amendment should be the only basis for where this right to privacy is derived from. So nothing else, just solo on its own. The 14th Amendment's due process clause is enough to justify a zone of privacy and this whole new idea. And then Justice White concurred in judgment. So let's briefly talk about the differences and concurrences and dissents, because there's a lot of versions of what can come from a concurrence or dissent. So basically, depending on what you agree on and what you disagree on, you can write a concurrence in judgment, which is that you agree with the ultimate decision that the majority has made, but you do not agree with the reasoning that they got there to. And a concurrence in part is similar, except you don't agree with the judgment. It's the flip side, if I'm not mistaken.
Well, you can still agree with the judgment.
Amazing.
It's kind of a mixed bag of like, in part meaning I kind of agree with you guys. Here's where I differ. So yeah, right. the judgment might not be completely agreed with,
but it could be. But like typically they would also write concurrence in judgment. So you can have an opinion that's. I think there was one that I read recently that was concurring in part, dissenting in part, concurring in judgment, which just I know insane. Which means you agree in some, you disagree in some, but you agree with the ultimate conclusion.
But that just feels like a concurrence in judgment.
Feels like, yeah, exactly.
Yeah.
It just feels like you could have skipped all of that and just written the last part.
I guess it makes sense if you're answering multiple questions.
Yeah, I think it was a multi-amendment issue.
Okay.
So it was spanning a lot of areas.
Wow.
Yeah, it was pretty insane. If I find it, I will quote it in the next episode because it was quite insane. But Justice White concurred in judgment and argued that the Connecticut law did not pass the rational basis scrutiny that we had discussed. And this is the normal standard of review used by the court, and it looks to whether the law at issue is rationally related to a legitimate government interest. So we will talk, I guess, if we cover any separation of powers cases down the line, the doctrine of compelling government interest and whether state and federal and even local governments can step in if they have a valid reasoning to do so. Typically, courts apply strict scrutiny when it comes to these laws, stating that the government really has to apply an exact and definite reasoning as to why they are infringing on certain rights. So that was what Justice White basically argued that there wasn't really a substantial interest that the government had in limiting contraceptive to at least married couples, considering, like, at the time it was pretty regularly afforded that married couples were engaging in sex, and it was just kind of like this thing of, if you're single you shouldn't be, if you're married you are. So in his mind there was no reason why a married couple who's already in a sexual relationship shouldn't have those rights afforded to them. And I quote from Justice White's concurrence: "I wholly fail to see how the ban on the use of contraceptives by married couples in any way reinforces the state's ban on illicit sexual relationships." So basically saying, I don't see how this is like trying to help limit the amount of, like, I guess, promiscuity in the state if married couples are already like, it's just
and in their definitions, sex between a married couple would not be illicit.
Right.
So denying them contraceptive in no way is compelling to Justice White in preventing illicit relations.
Yeah. I think these are some of the cases where I find in the majority opinions, or any opinions really written, as well as, like, I think it was Roth, the U.S., which was the ban on, like, porn or something, and the state, or maybe it was California, be something, I forgot, but it was like, I just find their wording very hilarious when they kind of dance around the issue of, like, sex. I think it's very funny that they have to deal with that. But
yeah,
here we are.
Yep. So in addition to those 3 concurrences, there were also 2 dissents. One by Justice Black, who was joined by Justice Stewart. He could not get behind the idea of the loose reasoning that the majority used regarding the penumbras. The fact that privacy is never mentioned explicitly, he says, means the court has no right to strike down the Connecticut law, saying privacy cannot be derived. This is a flawed argument that you're making. These zones and penumbras don't exist. This law is certainly constitutional. He wrote, quote, "I get nowhere in this case by talk about a constitutional right of privacy as an emanation from one or more constitutional provisions. I like my privacy as well as the next one, but I am nevertheless compelled to admit that the government has a right to invade it unless prohibited by some specific constitutional provision." So his thought is that a constitutional amendment needs to be passed to afford people the right to privacy, rather than just being able to pull it out of thin air, as the justices in the majority did.
Yeah.
So the second dissent is Justice Stewart, joined by Justice Black. So the 2 dissenting justices each wrote one and joined the other's dissent as well. And he stated that while he personally viewed the law as, quote, uncommonly silly, the court had to find it constitutional for the reasoning, some of the reasoning mentioned by Justice Black.
All right. Well, we can briefly talk about some implications of Griswold. So it did technically create the right to privacy, but only exclusively applied to married couples. And then again, that right to privacy, I mean, as we see now with the majority opinion and concurring opinions in the recent Dobbs v. Women's Health Organization, I think is the full, or Jackson Women's Health Organization, which was the case that struck down Roe, which is all based on the same implied right to privacy. The current justices are having kind of the same opinions that Justice Black and Justice Stewart were voicing in their dissent, in that it was kind of, you can't really pull those rights out of thin air. I think it's, in Dobbs, a little bit less compelling, because that had been a standing precedent for 50 years. But I understand the reasoning, I would say, behind Justice Stewart and Justice Black's dissenting opinions when it comes to that. But implications moving forward, Griswold laid the basis for most LGBTQ and women's rights cases going forward. It was the basis for Roe. It was the basis for Lawrence v. Texas, which we'll talk about. It was the basis for Obergefell, which gave people the right to federally marry each other. Thank you very much. And then more, I guess, important to us and important to this episode, it directly preceded Eisenstadt v. Baird, which we will now talk about the case facts for. So William Baird, he was a clinical director for the brand Emco, I believe is the name.
Hmm.
Yeah, Emco. So he was a clinical director for this contraceptive manufacturer, Emco. And he was giving a lovely little guest lecture at Boston University. And in Massachusetts, there was a state law that only married couples could obtain contraceptives, and that nobody who wasn't a registered doctor or physician could provide or publicly endorse contraceptives.
So you can see the effects of Griswold in the case here. I mean, they have a law that, excuse me, is specifically tailored to married couples can. And so they're adhering to the rationale in Griswold there that they said married couples have a right to privacy, derived as well a right to contraception.
Yeah, and similar to Estelle Griswold in setting up the Planned Parenthood in Connecticut, William Baird in this case knew that he was going into a state and giving a guest lecture where he would receive a felony charge for providing contraceptive care, which he this goes it's just like a funny thing to me. The form of contraceptive that he handed out to a few women, I think, at this Boston University lecture is, and I quote, Emco vaginal foam. So he was just handing out vaginal foam to people and talking about overpopulation and contraceptives in this lecture. So
quite the goodie bag at the end of the lecture.
Right? I was kind of like, I would love to be there.
I wish we got treats at the end of guest lectures.
Exactly, but instead we just get silence. Yeah, so this Massachusetts law stated that only registered doctors, surgeons, or pharmacists could provide any form of contraceptive care. Baird was none of those. He was a director at a manufacturing company. Like, he had no medical training that I found or that I know of. And he was just simply not authorized to distribute these contraceptives. And he was brought up with a felony charge, I believe, only fined, I think similar to Griswold, it was not much. He didn't serve any time. He kind of just chilled out, paid a fine. But then he filed suit in the state of Massachusetts. And the whole point of him going into Massachusetts, like with Griswold, was to bring this case to the Supreme Court.
Yeah. He appealed his conviction.
Yes. Yeah. He made his way up, and then once the Massachusetts, I'll read this off actually. In 1969, the Massachusetts Supreme Court overturned his conviction, so he was completely free to go. But then he filed suit against the state of Massachusetts, so then he could eventually make it to the Supreme Court. So I believe the Massachusetts Supreme Court held that his distribution charge stood.
Yeah.
But his lecture, he was charged for the lecture he gave and the distribution. They lifted the lecture charge, kept the distribution one. So then he filed suit and
he appealed that,
to the Supreme Court. But it was under this whole, I guess, elaborate plan to extend the Griswold precedent to single people as well, instead of just married couples. And that is basically what it did. But if you want to talk about the issue.
Yeah, so the question that the court takes up is, did the Massachusetts law violate the right to privacy acknowledged in Griswold versus Connecticut and protected from state intrusion by the 14th Amendment?
Yeah, so in a 6-1 decision, shockingly, 2 justices recused themselves. Don't exactly remember who they were. Forgot to put that in there. But if you want to look it up on OYAs. It's probably there. And this was issued by Justice Brennan, who wrote one of the concurrences in Griswold. The court held that the law's distinction between single and married individuals failed to satisfy the rational basis test of the 14th Amendment's Equal Protection Clause. So, what we talked about, rational basis, must have a compelling government interest and must be narrowly tailored, and must apply strict scrutiny to these laws. They kind of just extended the constitutional right to single people.
The reasoning that the court used is that they said married couples were entitled to contraception under the Griswold precedent, and that withholding that right to single persons without a rational basis proved the fatal flaw in the Massachusetts law. The court did not have to heavily rely on Griswold to invalidate the Massachusetts statute. Quote, If the right to privacy means anything, it is the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. So, regardless of if you are married or single, you should have a right to privacy and a right to contraception in the same vein. You don't have to be married for that.
Yeah, absolutely. And I think we can briefly just discuss about implications of both Griswold and Eisenstadt. As we mentioned, laid the foundational basis for a lot of LGBTQ legislation, established the zone of privacy, all that. But something that I did, or some research that I did while researching this case, was that Eisenstadt and Griswold laid the foundation for Title IX to become
Really?
a thing. Yeah.
Huh.
Right? Kind of interesting. I found this from the official Title IX, or Title 10. Why the fuck? Not Title 9, Title 10, excuse me. Which is more of like a side of the planning of the family program. It's like a whole thing. So not Title 9, excuse me. Unfortunately. But as a female student athlete, we love Title 9. Stand by it. No discrimination based on gender.
Mm-mm.
The Title 10 family planning program became law in 1970, which directly followed Griswold and Eisenstadt, and was first funded in 1971 because of these two cases. And Eisenstadt specifically played a fundamental role because it did extend that right to single individuals.
Mm.
And it began to provide access to like single households or single parent households, like because under the Griswold precedent, if you had a kid but you weren't married, you wouldn't have received any government funding or significant government funding to be able to like Title 10 didn't expand, I guess, to single individuals.
Sure.
Without Eisenstadt. And yeah, they were able to, because of this funding, just generally provide like high quality family planning at the federal level, which is just like really sick. And today, millions of people rely on Title 10 for access to contraceptive services and supplies, along with other basic reproductive and sexual health care services. And honestly, without Eisenstadt, millions of those patients could have limited to no access to preventative health care and things of that nature. And it's especially important for younger people because it's like typically younger people are single. So, or like the younger you are, the more, I guess, vulnerable you are to not receiving reproductive care or reproductive education. So it really played a significant part in getting those programs off the ground and being able to extend that right to people who it would prior not be extended to.
So two incredible cases that really do have major implications for the rights that we receive today, and hopefully will continue to receive. Hopefully the court does not continue going down the path of attempting to invalidate these things. I can't imagine that they would ever overturn the right to privacy and truly require that an amendment be passed at the state or federal level in order to ensure privacy. But they've certainly done a number on it with the Dobbs decision, which is really unfortunate to see, and in a way rather unprincipled. I mean, I think that some of the concurrences rely heavily on the 14th and the 19th Amendment, saying that Ninth, thank you. Ninth Amendment saying, okay, says that people have unenumerated rights. This is certainly an unenumerated right. Also, it applies to the state, and the Due Process Clause provides for some kind of right to privacy, which makes sense. I also think that the use of the Fourth Amendment by Justice Douglas was very well reasoned too, in that the Fourth Amendment protects you in your home, and the court has had a number of cases on where you have a right to privacy derived from the Fourth Amendment. The curtilage around your home is one of the places, based on a number of factors in your home specifically. But there's and even you as an individual have a right to privacy in public. I mean, we have Katz versus United States, where the FBI wiretapped a public phone that he was using without a warrant, and the court determined that that was a violation of his privacy and an unwarranted search. So there's a number of, I think that the Fourth Amendment itself, on its face, confers a right to privacy of some kind, regardless of not explicitly saying it, but your protection from searches should certainly suffice to say that you have a right to private spaces and to have privacy.
Exactly. And I fail to see the logic behind if the Fourth Amendment applies to privacy within your own home, why that privacy shouldn't extend to your personal body.
Mm-hmm.
I think, yeah, that's
Exactly.
just my opinion.
No, the court has ruled that the privacy of the freedom from searches protects individuals, not entirely just places, but
People,
also
not places.
exactly. So I think that the privacy of the individual should extend out in a number of other ways, and that the Fourth Amendment is fine characterization or a fine justification for that.
Yeah, and like you were talking about in the Dobbs case, how I really don't see how the court is going to move further with denying the right to privacy via the 14th Amendment. To me, it just seems silly, and to me, in Clarence Thomas's concurring opinion in Dobbs, that's the scariest to me. It's truly frightening, because just interesting guy all around. But in his concurring opinion in that case, he wrote that because the 14th Amendment should no longer apply to Roe, and this right to privacy has now been called into question, we should then, as a court, revisit, and this justices do this often. They will, in concurring or dissenting or majority opinions, they will signal to states, to individuals, to like corporations that if you bring this before us right now, we are somewhat obligated to hear you out. And like they oftentimes have like they'll signal out that they want certain cases to be brought to them. I mean, like we talked about Marbury versus Madison, how John Marshall more directly worked through the system and got Marbury exactly to appeal.
Yep.
The justices now do it in a bit more of a discreet way, but I don't know about discreet, but Clarence Thomas basically said that the 14th Amendment should be called completely into question, and that the right to privacy should now be questioned in the cases of absolutely insane Obergefell, which again we discussed is the federal right to gay marriage, Lawrence v. Texas, which we'll talk about next podcast episode as well, and it places a federal ban on the criminalization of sodomy, which again is like a step towards securing LGBTQ rights. And then the one that is baffling to me, actually baffling. First of all, Clarence Thomas is in an interracial marriage. Let's talk about that right now. He's married to a white woman. He cited Loving v. Virginia as a case that should be revisited. Loving v. Virginia it placed a federal ban on the criminalization of interracial marriage.
Yep.
He's in one, like, oh, it makes me so frustrated that it's just like, surely he does not mean that. Like, surely, and that's what kind of gives me a bit more peace, that he's really not going to review a 1960 something case, 61, 63, something like that made it illegal. And I'm kind of just like, bro, you directly benefited from it. Same thing with him in affirmative action. He directly benefited from it, but now he just doesn't seem to care. But yeah, there's just a lot that I don't necessarily like about that man.
Yeah, and then speaking of in other cases in Dobbs, or in other decisions or concurrences in Dobbs, Justice Roberts, or Chief Justice Roberts, concurred in judgment and said that, or in part, and he agreed with a lot of their reasoning, but determined that he didn't think that Roe v. Wade should be overturned, which makes no sense. Makes no sense, because their entire reasoning points to overturning Roe.
Right.
And he, he's shown many times, is a Chief Justice who's very interested in maintaining the prestige and people's trust in the court.
Yes.
And so he had an understanding, probably correctly, that if they were to overturn Roe, people would not trust the court, they'd not like the court, because it's not a good decision. It's overturning an extremely long-standing precedent. And he determined to write, and he just kind of talks in circles and rambles for a while and then says, so I agree with them, it should be left up to the states, But we shouldn't overturn Roe, which is just like, how can you not overturn Roe if this is the decision that you're making?
Right.
So it's not the most principled concurrence that's around.
And it kind of just shows, again, like you said, he will go to any length, I think, at this point, to solidify himself as like the most moderate out of the conservative coalition on the court. Which again, gotta respect him for. Honestly, I give him mad props. It doesn't look like an easy job to be able to corral some of those personalities. And yeah, I mean, there's like now current talks of Clarence Thomas resigning in Donald Trump's 4 years now in office. Honestly, what do you think about that? We haven't talked about it. I'm curious. I think he should. Personal, if you're coming from a perspective of a Republican in the Senate,
if you're coming from a conservative perspective, and you have Justices Thomas and Alito who are getting up there in age, Trump only has one more term. He cannot run again. He is constitutionally barred from running again. So it's, who knows if there will be a Republican administration. But if you're coming from their point of view, or even from President Trump's point of view, you're going to want them to retire so that you can appoint hyper conservatives like they are to the court. Younger people in their 40s or early 50s will be on the court for another 30, 40 years. I mean, that's how Thomas and Alito have been on the court for quite a long time. Thomas for much longer than Alito, but still. And so if they retire now and Trump is able to appoint people who match his values and match their values, then it will solidify the court's conservative majority for quite a long time, and perhaps even make it more conservative, which I'm not sure you can get much more conservative than Clarence Thomas. But I feel like Trump and the Federalist Society will find someone who is a judge and who does match that level, which is just absurd to think about. Although I don't think they're going to retire off the bat. I think they both enjoy their positions and the extra benefits that they receive from them, regardless, aside from the compensation. Book deals, vacations, private jet flights, homes, all sorts of things. So I think that they will not retire until the very end of this term. If they retire at all, I think there's a part of them that will say, no, I'm healthy enough to stay on the court. There's going to be another Republican administration, or there might not even be a care for that. Regardless of the fact that they are hyper-conservative and those are the leanings that they share, there could also be the thought of, my position is more important. Yeah. I also think, as much as we would like to believe that the court is nonpartisan, that the court would like to be at this sort of higher level in comparison to all the little floor mice in the Senate or in the House, I think that inherently now they are very concerned with politics. And I don't, at least in the rationale behind decisions, I don't think they, at least with this modern court, I don't see them extremely going into the side of playing partisan politics, but it's certainly more than past courts have. So I do not doubt that at least Thomas, I believe, is going to resign. I don't think Alito will. I think Alito is going to stay through it. He is younger. He has been on the court a shorter period of time. But Thomas, if I was a conservative, I would say that he should retire. Yeah, he's in the top, I believe, in the top 5 longest serving justices ever. So been on there a while. Made his mark in many ways. The longest was it? Oh, I should know this. This feels like a trivia point we should know. I know. Marshall is the longest serving Chief Justice, although I think he's like the 5th longest serving justice overall. Wow. Yeah. I don't know entirely who's the first. I feel like part of me feels like it's Douglas, but I don't know. That's something, so for some reason that's sticking in my head, but I feel like it could be someone else. Maybe. We'll look it up and let you know at the start of the next episode when we cover Lawrence, Obergefell, and Bostock. But thank you very much for watching this installment of the Supremely Simple Court. We hope we gave you a great overview of where the right to privacy is derived. Yeah. Looking forward to see you next time. Stay super freaky. We love you. Bye. Bye.